This guide has been prepared by the Department of Prevention of the Labour Inspectorate of Estonia to provide guidance to the employee on how to fill out the labour dispute application. First, we explain that the Labour Dispute Committee is an extrajudicial authority within the Labour Inspectorate, which resolves labour disputes and consists of 3 members. Turning to the Labour Dispute Committee is free of charge. In order to turn to the Labour Dispute Committee, an application has to be filled out. The application must be submitted in Estonian, and the process of resolving labour disputes is in Estonian as well. It is possible to assign a person to represent you in the Labour Dispute Committee. A representative can be any person, such as a friend, a lawyer, a family member, except a witness in the current case. However, it is important that the person would speak Estonian. If you would like to appoint a representative, you need to attach a signed letter of authorization to the labour dispute application. The application form can be found on the webpage of the Labour Inspectorate, www.tei.ee. Once you have our webpage opened, you need to choose from the menu bar the option Work Environment and Relations. Next, Labour Disputes. By clicking on the link Application, the application form will be automatically downloaded to your computer. Now let's open the form and have a look on how to fill it out. The application must be filled out in capital letters if you're submitting the application on paper, that is filling it out by hand. However, if you're filling the application out in the computer, you may use lowercase letters. Here you may add your and your employer's data. If you have made a choice as to the place of resolution of the labour dispute matter or the type of proceeding, you may place an X in the box next to the selected option by clicking on the left button of the mouse. You can move up and down the list of the text box with the arrow keys on your keyboard or with a mouse click. Numbers can be added by pressing the Enter key. Under the description of circumstances, there is an empty text box where text can be added in free form. If there isn't enough space, the box will automatically expand when you add more text. Here you can see the rest of the application. However, we will talk more thoroughly about it later on. If you're signing the application digitally, you can add to the signature box, Sign digitally. Next, we are going to talk more precisely about the content of the application. The petitioner can be both an employee and an employer. The name of the enterprise, the registry code, and the address of the legal person need to be indicated if the petitioner is an employer. As an employee, you must state your full name, personal identification code, phone number, email, and post address in the application. If you add an email address, it is important that you check the email regularly, as communication and transfer of documents with the Labour Dispute Committee takes place via email. If you do not have an email, you can insert a minus sign into the box next to the email, in which case the Labour Dispute Committee will send the necessary documents or invitations to your postal address. You must also include a postcode. If you do not know your postcode, you can use, for example, Omnivus Postcode Finder. In addition, it is necessary to state the workplace with accuracy of a county and city, and the job title. Regarding the opposing party, that is the employer, official name of the enterprise, registry code, contact number, email, as well as the official address and postal code of the employer must be stated. The workplace and the job title may be left unfilled, as this information is already included under the petitioner's data. Official company data, such as registry code and address, can be found in the employment contract or business register, which is located on the webpage ariregister.ric.ee. When searching the company's data in the business register with a keyword, you should make sure that what appeared as a result is in fact the right company. Next, we will try to search the data of one company in the business register. To do this, we need to enter the company's name or registry code in the search box and click Search from the commercial register. I want to search for a company by its name. As a result of the search, the company's name, registry code, and official addresses are visible in the initial view. Let's say we are also interested in the company's official email address. To find it, we have to go to the bottom of the page and choose from the table the option, the printout of valid registry card information in English, which is free of charge. Next, we will add the number shown as an image. After completing the search, we found the official email address of the company. In addition, information on the members of the management board can be found under the section Right of Representation. Coming back to the application, next you will need to make a choice as to where the resolution of the labor dispute will take place. As an employee, you can choose the labor dispute to be resolved at your place of residence, place of work, as well as the employer's official location. That is, if the workplace and the company's official location differ. The company's official address can be found in the business register. In agreement with the employer, the resolution of a labor dispute may take place in another location. If you wish to choose another location, you must enter into a written agreement and attach it to the labor dispute application that is going to be submitted to the Labor Dispute Committee. However, we would like to draw your attention to the fact that the resolution of labor disputes is not possible in every region, so when choosing a location, it is needed to also take into account the work areas of the labor dispute committees. The work areas of the labor dispute committees can be found on the website of the Labor Inspectorate www.ti.ee. Once you have reached our website, you have to select Work Environment and Relations from the menu bar. Then Contacts and Work Areas of Labor Dispute Committees. On this page, you will find the committee's work areas, postal addresses, and the email address of the Labor Dispute Committee, avaldused.tvk@ti.ee, to which a previously filled out and signed labor dispute application can be sent. If a place for resolving a labor dispute has been chosen, the next step in the application is to indicate how the application will be reviewed. In the ordinary proceeding, that is the session, the establishment claims are reviewed. For example, the claim to establish the wrongful termination of the employment contract. Also, the ordinary proceeding must be chosen if your monetary claims, such as unpaid salary or holiday pay, exceed €6,400. The written proceeding is intended for monetary claims up to €6,400, and it's also possible to resolve a labor dispute in a written proceeding instead of the ordinary proceeding if the employer recognizes the employee's claims. The conciliation proceeding is based on the voluntary participation of the parties. The purpose of this type of proceeding is to reach a compromise or an agreement. In order to choose the conciliation proceeding, you must reach an agreement with the employer in writing and attach it to the labor dispute application. Under claims, it must be stated what do you want the Labor Dispute Committee to establish or order on your behalf. Claims may include, for example, to order the payment of unpaid salary or holiday pay, or as an establishment claim, to establish the employment relationship or wrongful termination of the employment contract. Monetary claims must be submitted in gross amount, that is before taxes, and in the case of monetary claims, the calculations or evidence must be attached in order to explain How did you determine the amount that you are claiming? Evidence in this case may be, for example, a payslip provided by the employer or a copy of the holiday calculator results if the claim is unpaid holiday pay. If you only know your net salary, that is the amount that the employee will receive after deducting taxes, you can use the salary calculator from the internet to find the gross salary. In the description of the circumstances, an explanation regarding the presented claims must be provided. This is the part where the employee has the opportunity to go into details. The description should answer the question, why have you turned to the Labor Dispute Committee? In this section of the application, you must justify your claims, that is to explain the circumstances on which the previously added claims are based. The presented circumstances must be linked to the existing evidence, which is also the evidence you attach to the application. According to the example shown in the video, this is a claim for unpaid salary, and in the description of circumstances, the employee explains that the employer has not paid his salary. The employee points out that according to the employment contract, his salary is €5 per hour, and having worked 100 hours as per work schedule for February, the employee has not received salary in the amount of €500. Files listed as evidence must be sent to the Labor Dispute Committee together with the application. The evidence that is attached to the application should also reflect in the list of evidence. The name you choose for a specific evidence should match the name of that file. For example, if an employee wishes to use a PDF file of a work schedule as evidence, he or she could name the file Attachment Number 1 Work Schedule and write the same name Attachment Number 1 Work Schedule in the list of evidence. We explain that evidence is any information that is necessary to prove or disprove claims. Typical evidence in the labor disputes are an employment contract, work schedule, bank account statement, correspondence payslip, etc. Evidence may also include, in addition to the previously mentioned, an image, audio file, damaged tool, poor quality work, witness testimony, or other physical evidence. Evidence must be submitted in Estonian. If the evidence is in a foreign language, it must be translated into Estonian. If you speak both Estonian and a foreign language, you can translate the evidence yourself. If not, you may ask your acquaintance to assist with the translation or contact a suitable translation agency. In this part of the application, it is possible to indicate the documents that are in the hands of the employer but are necessary for you in the dispute as they are related to your claims. For example, you can request the employment contract from your employer if the employment contract was made in duplicate, but you have lost your copy and the employer has not agreed to give you a copy of the employment contract. Please note, however, that the employer can only be required to provide the documents that he or she actually has. Thus, it is not possible to request an employment contract from your employer if the parties have not entered into an employment contract with each other in writing. As we mentioned earlier, the testimony of a witness can also be evidence. A witness can only prove what he or she has directly experienced and the facts that are relevant in the labor dispute that he or she knows. For example, if a witness was present when the employer handed over a declaration of termination of the employment contract to the employee. However, the witness's explanation that he or she heard from the petitioner or a colleague that the declaration of termination had been forwarded to the employee is not relevant. It is important to mention that if an employee wishes to involve a witness in a session, then this can be done on the basis of the witness's free will. In other words, an agreement must be reached with the witness. It is also the employee's responsibility to ensure that the witness appears at the session. The application must state the name of the witness and indicate the circumstances on which the witness testifies. And we have reached the end of the labor dispute application. Here you must confirm the labor dispute application with your signature, as well as that to the best of your knowledge, neither you nor your employer has previously turned to a labor dispute committee or court or entered into a conciliation agreement, in other words, a compromise. If you have any questions, we recommend that you consult with a counseling lawyer of the Labor Inspectorate. More information about resolving labor disputes can be found on the website of the Labor Inspectorate, more precisely in the section of Work Environment and Relations under Labor Disputes. All booklets can be found on the same website by selecting on the opening page Media and Publications, and under the section of Publications, Publications of the Labor Inspectorate. We thank you for listening, and we wish you success in filling out the labor dispute application.